In our previous lecture, we looked at the Supreme Court's rulings in 4 cases that challenged racial segregation in higher education and that were decided between 1938 and 1950. These were cases brought by lawyers for the National Association for the Advancement of Colored People, the nation's leading civil rights group. During these years, the NAACP's legal office was headed by a remarkable lawyer, Thurgood Marshall, who later became the first African American to sit on the Supreme Court. We saw how Marshall began his long-range campaign against school segregation with a strategy of encirclement and attrition. He felt that challenging the exclusion of black students from graduate studies and law schools in border states would produce favorable judicial rulings and would build precedent for a final assault on Jim Crow schooling in the Deep South. As we saw, Marshall brought suits that forced the admission of black students to graduate programs and law schools in Missouri, Oklahoma, and Texas. But the Supreme Court declined Marshall's invitation in these cases to overturn the separate but equal doctrine of the Plessy case in 1896. We're going to begin, and devote the most time, to the case Thurgood Marshall picked as the first challenge to school segregation in the Deep South. This case began in 1947 in the small town of Somerton, South Carolina. Almost all the black families lived on farms, but few owned their land. They raised cotton and worked as sharecroppers for white owners. More than 2/3 of the black families earned less than $1,000 a year, and more than 1/3 of all black adults could not read or write. In fact, hardly any had gone beyond the 6th grade, in schools that held classes just 6 months a year, so that children could weed and pick cotton. The county spent $179 for each white child in public school, but only $43 to educate each black child. The schools for blacks had no desks, no electricity, and no indoor plumbing. This was the reality of Jim Crow education in 1947, not only in Clarendon County, but in most states in the Deep South. Joseph Richburg, a black teacher, said, "There was a lot going on that we didn't like, but everything was fine so long as we kept saying yes, sir, and no, sir, and tipping our hat." But one black man in Clarendon County did not tip his hat to whites. The Reverend Joseph Delane was pastor of the African Methodist Episcopal Church in Somerton, and he also taught in a rural black school. His students walked to school along dirt roads, some for miles. Their clothes were often spattered with dust or mud from the school buses that carried white children to their school in a large brick building in Somerton. But the county school board did not provide any buses for the black children. Reverend Delane approached a black farmer named Levi Pearson, who owned his land and was known for standing up to whites. Pearson had to drive his 3 children 9 miles to the Scotts Branch School. He agreed to sign a petition that had been drafted for Delane by Harold Boulware, the state's only black civil rights lawyer, asking the county school board to provide buses for black children. But the case was dismissed after county officials discovered that Pearson's farm straddled the line between 2 school districts. He paid property taxes in one district, and his children attended school in another. Levi Pearson paid for his stand. Every white-owned bank and store cut off his credit. No white farmer would rent him a harvester, and his crops rotted in the field. But Pearson did not give up. In March of 1949, Harold Boulware summoned him and Reverend Delane to his office in Columbia, the state's capital. Thurgood Marshall had come from New York to South Carolina, looking for plaintiffs who were willing to ask for more than buses. Marshall told the black farmer and the black preacher that he wanted to file a suit that would demand equal schools for black children. And he wanted to file that suit against Clarendon County to expose the myth of separate but equal in South Carolina's most unequal county. Marshall asked the 2 men to find at least 20 plaintiffs to join the suit and spread the risk of retaliation. It took Pearson and Delane 8 months to find 20 black parents who were willing to challenge the county's white power structure. The first in alphabetical order was Harry Briggs, a Navy veteran with 5 children. Briggs pumped gas and fixed cars at Mayor Kerrigan's station in Somerton, and his wife Eliza worked as a motel chambermaid. Harold Boulware drafted a complaint that asked for equal funding of the county's schools, buildings, teachers, books, and buses. He filed the complaint in federal court in Charleston in November of 1949, listing Thurgood Marshall as co-counsel. The first defendant in the suit was Roderick Elliott, the county school board chairman, and whites quickly retaliated. Virtually every plaintiff paid a heavy price for joining the suit. Mayor Kerrigan fired Harry Briggs on Christmas Eve, handing him a carton of cigarettes as severance pay. Eliza Briggs lost her motel job. John McDonald, a combat veteran of Iwo Jima, lost his farm credit. Bo Stooks lost his garage job, and James Brown was fired by a trucking company. Reverend Delane's house was burned to the ground, and he left the state to protect his family. Thurgood Marshall was delighted when the case of Briggs versus Elliott was assigned to a federal judge named J. Waddies Waring. Judge Waring was a South Carolina native who was born in 1880. His father had owned slaves and his uncles had fought for the Confederacy. But Waring had turned against his state's Jim Crow system. He ruled in 1945 that South Carolina must equalize the salaries of black and white teachers. And in 1948, Marshall had argued before Waring that state officials could not exclude blacks from voting in primary elections. It is time for South Carolina to rejoin the Union, Waring had written in this case. But Judge Parker allowed Marshall to proceed, and he called Kenneth Clark to the stand. Clark was an eminent black social psychologist with a doctorate from Columbia University. He was also the nation's leading authority on the impact of racial segregation on black children. As we'll see in our next lecture, Clark's testimony at the Briggs trial had a great impact on the Supreme Court's later ruling in the Brown case. His testimony was essential to the case against Jim Crow schooling. Marshall's amended complaint argued that the inequality of Clarendon County schools was not the real issue before the judges. The real issue was the system of segregation. Marshall argued that racial separation was per se unconstitutional. This Latin term means by itself. In other words, even if the black and white schools were equal in quality, segregation by itself violated the Constitution. Marshall called Kenneth Clark as a witness to show that enforced segregation made black children feel inferior to whites. And these feelings of inferiority stemmed from the Jim Crow system, which taught black children they were unfit to attend school with white children. Clark made this case with a simple but revealing test. He had visited the Scotts Branch School in Clarendon County and sat down with 16 black children, one at a time. He showed each child a pair of dolls that were identical in every respect but color. One doll was white and the other was brown. Clark asked each child, "Give me the white doll. Now give me the colored doll." The kids all picked the right doll. Then Clark asked, "Give me the doll that is a nice color. Give me the doll that looks bad." 9 of the black kids said the white doll had the nice color, and 11 said the brown doll looked bad to them. Clark explained his doll test to the judges and then stated his conclusion. These children in Clarendon County, like other human beings who are subjected to an obviously inferior status in the society in which they live, have been definitely harmed in the development of their personalities. The effect of segregation, Clark added, was to create basic feelings of inferiority in black children. Thurgood Marshall did not expect Clark's testimony to sway Judges Parker and Timmerman. He was building a record for the Supreme Court. And when Parker issued the panel's ruling in June of 1951, his opinion did not even mention Clark's name. Parker stood firmly behind the Plessy decision, calling it overwhelming authority, which we are not at liberty to disregard on the basis of theories advanced by a few educators and sociologists. School segregation, Parker concluded, was grounded in reason and experience. He gave the school board 6 months to report on its progress toward equalizing the county's black and white schools. Judge Timmerman joined Parker's opinion, leaving Judge Waring in dissent. His lengthy opinion covered the history of slavery and segregation and denounced what he called the sadistic insistence of the white supremacists in declaring that their will must be imposed, irrespective of the rights of other citizens. The next case to reach the court began in the small town of Farmville, a town of some 5,000 residents in the tobacco-growing region of southern Virginia. Prince Edward County, of which Farmville was the business and government center, was almost evenly divided between blacks and whites. More than 2/3 of the county's black adults had not gone past the 6th grade, and their children attended overcrowded and run-down Jim Crow schools. The campaign against segregated education began with a protest march on the morning of April 23rd in 1951. The march was led by a 16-year-old girl named Barbara Rose Johns, who was a junior at the all-black Robert A. Moton High School. She had organized her fellow students to demand that the county build a new school and replace the tar paper shacks in which overflow classes were held. The shacks had no insulation or electricity, and students wore their overcoats to stay warm in the winter months. After the school board ignored their repeated demands, Barbara recruited a small team to plan a strike. She had someone call the school's principal and tell him that students were in trouble at the downtown bus station. After he rushed out, Barbara sent her team members to each classroom, telling the teachers of an emergency assembly in the auditorium. When the students gathered, Barbara took the podium and told the astonished teachers to leave. One teacher who objected was grabbed by the arms and hustled out. Barbara then informed the students that she was leading a march to the school board office in downtown Farmville. The marchers shouldered picket signs that had been stored in the carpentry shop and paraded to the town center with signs that read, "We are tired of tar paper shacks. We want a new school." The Moton students remained on strike until 2 lawyers from the NAACP office in Richmond arrived in Farmville. Spotswood Robinson and Oliver Hill had received a letter from Barbara Johns asking for legal help. They met with the students and told them the NAACP, as Robinson put it, would be interested in nothing short of a desegregation suit. Barbara's parents were concerned about her safety and sent her to live with relatives in Alabama. So Dorothy Davis, a 15-year-old Moton student, became the lead plaintiff in Davis versus Prince Edward County. The NAACP lawyers again called Kenneth Clark, who testified about his interviews with Moton High students. They all told him, Clark said, the conditions in their school made them feel that whites wanted to keep blacks down. The 3 federal judges who decided the case in March of 1952 were all natives of Virginia, loyal to its customs and traditions. There was never any doubt about the outcome of the trial, Oliver Hill said. We were trying to build a record for the Supreme Court. The judicial panel once again ignored Clark's testimony. Judge Albert Bryan wrote that school segregation in Virginia, as he put it, has for generations been a part of the mores of her people. In practice, it has begotten greater opportunities for the Negro. We have found no hurt or harm to either race. This ends our inquiry. But Bryan's ruling did not end the Davis case. Thurgood Marshall authorized his Virginia colleagues to file an appeal with the Supreme Court, which granted the petition for review. A third case began in the nation's capital, just a mile south of the court's marble building. On September 11th of 1950, 11 black children filed into the principal's office at John Philip Sousa Junior High in southeast Washington, D.C. They were escorted by an outspoken and determined black man named Gardner Bishop. He operated a barber shop in the city's black section about 2 miles north of the White House. Bishop had organized a parents' group in 1947 to protest the overcrowding of Washington's black schools after his daughter, Judine, was turned away from the all-white school nearest to her home. Segregation in the capital schools had been imposed in the 1860s by Congress, which governed the District of Columbia. Congress had also required that equal amounts be spent for the education of children, regardless of race. But the district school board had ignored this mandate. In 1950, blacks made up more than a third of the city's 800,000 residents, but their kids were squeezed into overcrowded schools, while hundreds of seats remained empty at the all-white schools. Gardner Bishop attended every meeting of the district school board and finally got tired of the excuses its members gave for not building new schools for black children. That's why he took the 11 black kids to Sousa Junior High, a brand new school with several empty classrooms. He knew they would be turned away, but he wanted to make a point. One of the students who left the Sousa school that day was Spotswood Bowling Jr., a 12-year-old whose widowed mother worked for the federal government as a bookbinder. Spotswood spent his 7th grade year at Shaw Junior High, an overcrowded school in a rundown neighborhood. He became the lead plaintiff in a suit that had been prepared by James Nabrett, a Howard Law School professor who had volunteered to help Gardner Bishop's crusade for better schools. The first defendant in the case was Melvin Sharp, the president of the district school board. James Nabrett agreed to file the suit in Bowling versus Sharp with one condition. He wanted to launch a direct attack on the separate but equal doctrine of the Plessy case. The complaint that Nabrett drafted made no mention of unequal school facilities in Washington. It also did not mention the Equal Protection Clause of the 14th Amendment, which affected only the states. The District of Columbia was not and still isn't a state. So Nabrett based his complaint on the Due Process Clause of the Fifth Amendment, arguing that racial segregation deprived black children of their liberty to use the same public schools as whites. But the Bowling case never reached a trial. Ruling in April of 1951, District Judge Walter Bastian dismissed the suit without an opinion. Nabrett appealed this ruling to the Federal Court of Appeals in Washington, but the Supreme Court added the Bowling case to its docket in October of 1952 without waiting for an appellate decision.